Welcome everyone to this educational webinar provided by Foley and Lardner LLP. Today's topic will be overtime exemptions, what's new and how it affects you. Hello, my name is David Pulio and I'm a staff member with Foley and will be assisting with the administration of this webinar. Before I turn the presentation over to our speakers, I would like to go over a few housekeeping items regarding this program. Today's program will last approximately 1 hour, followed by a short question and answer session. Questions can be answered and entered via the Q&A widget, which is open on the left-hand side of your screen. We'll get to as many as we can, time permitting. Please also feel free to follow up directly with our presenters if you have questions specific to your particular organization. The webcast console you're looking at can be completely customized. You can resize or move any of the windows that you see on the screen, including maximizing the PowerPoint presentation. If you experience any technical difficulties, please visit the webcast help guide by clicking on the help button below the presentation window. It is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com within the next few days. You may also find a copy in the resource list widget, which is open on the left-hand side of your screen. And as a final reminder, today's program is being recorded and will also be available on Foley's website within the next few days. So at this time, I'd like to introduce today's speakers. We have with us today two of Foley's litigation partners with the labor and employment practice. Carmen Couden focuses her practice on providing practical guidance and proactive counseling regarding best practices designed to help employers avoid labor and employment disputes and comply with the law. To that effect, Ms. Couden frequently represents and counsels employers on compliance with complex governing statutes and regulations, such as the Family and Medical Leave Act, the Uniformed Services Employment and Reemployment Rights Act, Executive Order 11246, and the Americans with Disabilities Act. Kamran Mirrafati's practice covers a wide range of labor and employment law with a particular focus on management-side labor relations. He also regularly counsels employers in a variety of human resources issues, including wage and hour compliance, employment agreements, leaves of absence, and personnel policies and practices. Mr. Mirrafati also has represented clients across a diverse spectrum of industries, including oil and gas, communications, hospitality, retail, healthcare, finance, manufacturing, and education. Complete bios of both of our presenters can also be found in the resources list widget to your left. So at this time, I will turn it over to Carmen Couden to start things off. Thank you again for joining us and enjoy the webinar.
Thanks, David. So today we're going to be going over a number of things, starting off with just some basic information about the Fair Labor Standards Act to get us up to speed. Then we're going to talk about the white-collar and highly compensated employee exemptions, which are really the exemptions that are affected by the Department of Labor's final rule. Then we'll actually dive into that final rule on those white-collar and highly compensated employee exemptions, talk a little bit about the impact of the final rule, and then really dig into some compliance strategies and action steps that you as employers can take. And finally, we'll end with a question and answer session. So with that, we'll start off with FLSA basics and talking a little bit about coverage under the Fair Labor Standards Act. And this is important because if you're not covered by the Fair Labor Standards Act and you don't otherwise meet the various requirements for coverage, you don't really have to worry about this rule because you're not covered by this rule. So there are a couple of different ways that you can be covered or your employees can be covered under the Fair Labor Standards Act. The first is if there is enterprise coverage for your business or for your organization. And so coverage under the Fair Labor Standards Act for organizations or businesses applies to those businesses or organizations that have annual revenues, either sales or business that's being done, of at least $500,000 per year. If you're below that threshold, generally speaking, with some exceptions that we're going to talk about in a minute, you don't qualify for enterprise coverage. Nonprofits generally are not covered enterprises unless they're also engaging in commercial activities. And things that are not commercial in nature aren't counted toward that $500 threshold. So for example, activities that are charitable in nature, those aren't considered commercial activities. Things like providing shelter or clothing or food to the homeless, providing counseling services, doing disaster relief, those are all things that are activities that are charitable in nature and not considered commercial activities. So any revenue or any dollars that come in as a result of any of those kinds of things don't count toward that $500,000 threshold. Likewise, if you've got income in the form of donations or dues that are being used for a charitable purpose, those also are not factored into that $500,000 threshold. In addition to that $500,000 revenue requirement, there are some named enterprises that fall within enterprise coverage regardless of how much dollar volume of business they have. And those are listed for you here. Those include hospitals, residential care facilities for older adults or persons with disabilities, schools for children who have disabilities or who are gifted, your various federal, state, and local governments, and then preschools, elementary and secondary schools, and institutions of higher education. In addition then to that enterprise coverage, which is geared toward the actual business or organization itself, there's also individual coverage under the Fair Labor Standards Act. And these are employees that are covered as individuals, separate and apart from whether or not their employer otherwise comes within the enterprise coverage. So individuals that are individually covered under the Fair Labor Standards Act are those employees who are regularly engaging in interstate commerce or in the production of goods for interstate commerce. So generally speaking, employees whose work is involving or relating to moving people or things across state lines are going to be covered under individual coverage. So some of the examples of these kinds of activities include employees who are regularly making out-of-state phone calls, are receiving or sending interstate mail or other kinds of electronic communications. If they're involved in ordering or getting goods from out-of-state suppliers, they're handling credit card transactions that are, of course, crossing state lines, or performing accounting or bookkeeping for activities like those just mentioned. Those individuals are generally going to be covered as individuals under the Fair Labor Standards Act. So now we'll talk a little bit about protections for covered employees.
Thank you for starting it off, Carmen. So if an employer or the employees are covered by the FLSA, they are given some protections under the law. First, they must be paid a minimum wage for all hours worked. The federal minimum wage right now is $7.25. As I'm sure many of you already know, many states have their own minimum wages as well. California, for instance, right now is $10 an hour. But under the FLSA, it's currently $7.25. In addition to minimum wage, employees must be paid overtime if they're not exempt from the requirements of the law. And overtime has to be paid for all hours worked over 40 hours in a work week. There are some states that have daily overtime, such as California, which requires work over 8 hours a day to be paid overtime, as well as work over 40 hours a week. If an employee is entitled to overtime, they need to be paid 1.5 times the regular rate of pay. It is important to know that the regular rate of pay is not always the same as the employee's hourly rate of pay. Regular rate includes compensation such as non-discretionary bonuses or commissions. If there's a payment that's clearly discretionary, or if it's a gift of some kind, that type of compensation is not normally included in the hourly rate. There are certain exceptions under the law that, if you have any questions, we can point out. But for the most part, employees' compensation, any compensation for the most part, should be included in the employee's regular rate of pay when determining how much overtime to give to an employee. So there are certain exemptions from the overtime requirements. If an employee meets a certain salary requirement, as well as certain duties. These exceptions include the white-collar exemption, which include things like the executive exemption, the administrative exemption, the learned or creative professional exemption, and certain computer professionals. Just to give a quick overview of each of these exemptions, the executive exemption requires that the employee have a primary duty of managing the enterprise or managing a recognized department of the enterprise. The employee must also regularly direct the work and manage the work of at least 2 or more full-time employees. And they must have the authority to hire, fire, or discipline these employees. Or if they don't actually have the authority to do it, they need to be given their recommendations for hiring, firing, or promotion must be given particular weight by their superior. The administrative exemption requires that the employee perform, as part of their primary duties, office or non-manual work that's directly related to the management of the general business operation. In addition, the employee must have primary duties that involve the exercise of discretion and independent judgment with respect to matters of significance. The professional exemption, there's a few different aspects of it, but for the most part, you could either be a learned professional, which has some kind of advanced knowledge or advanced degree, or you could be a creative professional, which involves work requiring things like invention, imagination, or originality, or some specific talent. And the computer exemption applies to certain employees, such as computer analysts or computer programmers. In addition to these duties, as I'll explain later, the employee must meet certain salary requirements. As far as there's another exemption as well that's unrelated to the duties exemptions of the white-collar ones that I just mentioned, which involves the highly compensated employee exemption. This currently requires that the employee be given at least $100,000 in salary, but as Carmen will explain later, that has now changed to $134,000, I believe. But currently, if an employee is making over $100,000 a year, they would be automatically exempt from overtime under the FLSA. As far as there's other exemptions as well, which we're not going to discuss in this presentation because they are not affected by the new changes. But as you can see in the slide, there's exemptions for commissioned salespeople, there's exemptions for drivers, certain mechanics, seasonal workers, plus a lot of other exemptions which are not going to be affected by the new rules. For this presentation, we'll focus only on the white-collar and highly compensated employee exemptions. So going on to the details of these exemptions, which I've already mentioned, there is a salary requirement. Currently, the salary requirement is $455 a week, or $23,660 a year. If the employee meets the duty test of the various exemptions, which I just mentioned, and they have a salary of at least $455 a week, they would be exempt from overtime. But it's important to note that there are a lot of state law differences. For instance, in California, the employees need to be paid 2 times the minimum wage of the state, which currently is $10 an hour. So employees in California need to be paid a salary of $41,000 to be exempt from overtime. So it's important to know your own state laws regarding minimum wage to see if the FLSA would apply here and whether you need to look at the state law to see if there's any exemptions that apply there. Okay. With respect to the highly compensated employee exemption, which we also already discussed, employees must meet a necessary salary threshold of $100,000 a year and perform office or non-manual work. Now Carmen will address the new changes.
So diving into the new changes, basically, we've got some significant salary increases that we're going to be talking about. But you know, we've been hearing about this for a while. It didn't happen out of the blue. You know, we got some warning. Back in March 2014, President Obama, you know, started telling the Department of Labor to look at and evaluate and modify these white-collar exemptions to come into line with what the economics of today are. Then back in June of 2015, we actually got proposed regulations that indicated that the DOL was looking at really significantly increasing these minimum salary thresholds. And at that point was also talking about some possible revisions to the duties test that Cam just talked about. Then we had a fairly lengthy comment period in which, you know, lots of employer and employee groups did in fact submit comments to the DOL for consideration. And in May, we got the final rule being published in the Federal Register, and really, quite frankly, that final rule appears to have taken some of the comments received during the comment period into account, because we ended up with a final rule that was different in some regards than the original proposed rule, and in most cases, they were differences that favored the employers, even though in some cases they were only sort of slightly more favorable to employers. And so now we've got the final rule, the changes that are required by the final rule, which we're going to discuss next. Those become effective later this year on December 1st. But you should note, for any entities who are covered by the accompanying rule, which refers to a limited non-enforcement period, there is this special non-enforcement period that will extend through March 17th of 2019 for only providers of Medicaid-funded services for individuals with intellectual or developmental disabilities in either the person's home or in a residential home, or in facilities that have fewer than 15 beds. And one of the questions that the Department of Labor has already addressed about this special non-enforcement period is this 15-bed language, and they have indicated that that is a per establishment number, not something that's looked at enterprise-wide. So for any of you who might be affected by this special enforcement provision, you know, you're looking at it per facility, looking at 15 beds per facility instead of 15 beds as an entire company. So what do we have that is ultimately changing? Well, the first thing is the new minimum salary for the white-collar exemption. The minimum weekly salary is going to be increased to $913 per week, which equates to $47,476 per year. And that's going up from the current requirement of $455 per week, or $23,660 per year. So it's more than doubling. And the new salary that's going to be required is set up so that it's equivalent to the 40th percentile range of weekly earnings for full-time salaried workers in the lowest income region in the United States. And this will become important when we talk about the later increases that we're supposed to see also as a result of this rule. That 40th percentile number will be important for those purposes. As I mentioned, this is a spot where there was some change from the proposed rule to the final rule. This final required salary of $47,476 per year is less than the $54,440 that was included in the proposed rule. But again, it still more than doubles the minimum salary required for the exemption. The second change that is included in the DOL's final rule is a new minimum salary for highly compensated employees. Here, the minimum salary requirement is increasing from an annual salary of $100,000 per year currently to an annual salary of $134,004 per year come December 1st. Don't forget about that $4. You know, it's real easy to just say it's $134,000, but there really is that extra $4. And that is equivalent to the 90th percentile of weekly earnings for those full-time salaried workers in the lowest income region in the United States. Which leads us to the automatic increases that are really the third change provided for under the final rule. For the first time ever, the rules now provide that these minimum salary thresholds are going to automatically be increasing every 3 years. Back when the rule was originally proposed, these were proposed as annual increases. So this was a win for employers to get a longer period of time in which the salary wouldn't increase, but there are still automatic increases that will be required. This is designed to really avoid the situation that we have right now where the salary hasn't been increased in so long that all of a sudden we're dealing with a huge increase all at once, a more than doubling of the minimum salary, and this increase rule is designed to address that going forward. So it's going to take into account things like inflation and living costs and ensure that the minimum salary thresholds stay at that 40th and 90th percentile levels going forward. The first increase will kick in January 2020, and initially the projections are that the first set of increased salaries in 2020 are likely to be around minimums of $51,000 for the standard white-collar exemptions and around $147,000 for the highly compensated employee exemption. In advance of any increases, the Department of Labor will be posting the new salary thresholds at least 150 days before they become effective in January of the affected year. So the first one, we should be seeing what those salaries are by August 2019. In addition to the increased salaries and the automatic subsequent increases, again for the first time, we now as employers will be able to satisfy up to 10% of the non-HCE standard salary with non-discretionary bonuses, incentive payments, or commissions, so long as those payments, those bonuses or those incentives or those commissions, are paid on at least a quarterly basis. This next note requires a little bit of explanation. It gets a little bit tricky in terms of how the 10% rule ultimately gets applied. The rules say that the 10% rule will apply to the standard white-collar exemption salary, but it doesn't apply to at least the first portion of the HCE salary. So the first $47,476 of the HCE salary, you can't be applying that 10% to that standard portion of the HCE salary. And again, happy to discuss this further because it does get a little tricky. But you can apply that 10% rule to those white-collar exemption salaries and to the additional portion of the HCE salary beyond that $47,476. It can't be applied to make up that initial portion of the salary. Also, the value of other fringe benefits, health insurance, dental, etc., don't get counted at all toward the salary threshold. And with that, I will switch back to Cam to talk a little bit about all the things that have not changed. Cam, did I lose you?
I'm sorry. Thanks, Carmen.
Sure, no problem.
So one thing that has not changed is that if you were originally covered by the FLSA, you are still covered by the FLSA. The new rules have not changed that. So if you were an enterprise that was covered, or if there was an individual that was covered, that coverage still applies. The next thing that has not changed is that the exemptions have not changed for the most part. If the duty for the white collar exemption, if you met the duties for the white collar or the highly compensated employee exemption, then that employee would still be covered, with the exception of the salary issue. So if to the extent that an employee was previously covered under the duties of the prior exemptions, they would still be covered under the new rule, so long as the salaries have been increased to comply with the new salary requirement. In addition to the other, so as well as the other exemptions that have not changed, all those other exemptions that I mentioned earlier, those have not still been affected by the new rule. So those would still apply, and there would be no changes required to your practices for those issues. As far as the duties test go for the white collar exemptions, those continue to apply as I mentioned. But this would give the fact that the new rules don't get implemented until December of this year. That time frame allows employers to time to review whether their employees are exempt under the exemptions and whether to actually increase salaries to comply with a new rule. So it would be a great time to do an audit of your employees to check to see if they're actually really exempt, and whether if they are actually exempt, you may want to increase the salary to meet the new requirements of the law. And we'll mention a few options for how to address the changes later on. There was a question that came up, I noticed in our Q&A, that it was asked whether if an employee meets the duties of one of the exemptions, but does not meet the actual salary requirements of the rule, whether the employee would still be exempt. And that's not actually the case. The employee has to meet both the duty test as well as the salary test to be exempt under the law. So that's important to keep in mind. Another thing that has not changed is the fluctuating work week. The Department of Labor has, the FLSA actually has an option for employees to be paid a fixed salary that covers a fluctuating number of hours. So if you were using the fluctuating work week to pay your employees, that option is still available to you under the new rule.
And so with that, we're going to talk about a little bit about the impact, and then we'll dive into the kinds of things that you all can do to deal with all of the changes that will be brought about by the final rule. So as far as the impact, I mean, we're really talking about a lot of dollars here. There's, a really significant impact on employers. Even the Department of Labor, which is certainly a proponent of this rule, is estimating that ultimately the final rule is going to affect, nearly 5 million workers who will ultimately need to be reclassified as non-exempt based on that salary change alone. And so what this means is really we're going to have the number of exempt white-collar employees getting reduced in most cases by more than 50%. So instead of sort of choosing to increase salaries, lots and lots of employers will really be looking at changing those positions from exempt to non-exempt. And in the first year alone, the Department of Labor is basically expecting that this rule is going to cost private employers somewhere in the neighborhood of $1.8 billion. And about $1.2 billion of that is they are attributing to payroll increases that will be required to bring exempt employees that are going to stay exempt up to those new salary thresholds, and about $637 million to costs that are related to employers, auditing their positions, figuring out how to implement additional time tracking processes and systems for those folks who will no longer qualify as exempt employees. And the impact is expected to be particularly significant in certain industries where there are, a larger number of lower paid managers in particular. These include places like the retail and the restaurant industries. In addition to the dollar costs, there are a number of other sort of less obvious impacts of this final rule. Ultimately, you've got potential issues that will crop up for employers related to possible redistribution of work to avoid overtime payments. So instead of having a person who was formerly exempt and working more than 40 hours per week be reclassified as non-exempt and get overtime for all the hours worked over 40, some employers in certain circumstances may say, you know what, we're gonna hire a part-timer, we're gonna hire a temporary worker if needed to take on those additional hours so that we don't have the additional costs associated with overtime for that individual. You also potentially have related impact on employee benefits if you've got more employees who are non-full-time workers, who are part-timers, because lots of times those part-time employees don't actually qualify for benefits under the employer's benefits plans. Other related ramifications for employers potentially due to maybe having more workers, because again, they're redistributing this work amongst additional people potentially. Impacts on whether or not somebody has Affordable Care Act coverage and requirements that they have to comply with, additional costs related to things like unemployment and other kinds of insurance. Those kinds of things are also impacts. And then, of course, you do have potentially an impact on employee morale and kind of how they view themselves in terms of importance to the organization. It really is a bit of a falsity for employees to think that their importance relies on whether or not they are classified as salaried or non-exempt, exempt or non-exempt. But there certainly are employees who take it a little bit as a sign of prestige to have a salaried exempt position, to not be subject to time tracking requirements, to not sort of have to write down, when they're working and when they're not working. Those kinds of things will be things that employers will have to work through with their employees as a result of these changes. And so with that, we're going to dive into actual strategies and options and action steps that employers can take to address the changes. And I'll turn it back to Cam.
Thanks, Carmen. So we have a few options that employers can do to comply with the new rule. The first option is that if you have an employee that is already close to that $47,476 threshold in salary, and they clearly meet the duty of the exemptions, of the white-collar exemptions, then it might be in the employer's best interest to raise the salary to that limit of $47,476 per year to continue classifying them as exempt from overtime. But you would need to make sure that the employee is clearly meeting the duties of the white-collar exemption in order to make sure they are exempt. Another option is that if you are aware that the salaried employees that you have work 40 hours or less for the most part, and they rarely work overtime, it may be in the employer's best interest to reclassify these employees to as non-exempt and make them and keep them below the threshold and make no other changes to their hours of pay. Because if they don't work overtime as much, then their pay will not really be affected by the new rule. Another option is for employees that actually do work more than 40 hours per week, but do not earn at least $47,476 per year, employers could reclassify those employees as salaried, not exempt, and then they would need to then track their hours worked, and the employer would then have to pay overtime for any hours worked above 40 hours per week. Another option is to reclassify employees and limit their hours so that their basic pay stays the same. So we would, so you could reclassify employees to non-exempt and then divvy up the work to other employees so that the employees are always below 40 hours per week. But this would require adding more employees, such as part-time or temp employees, to the workload. A fifth option is to reclassify employees and then adjust wages to account for the additional overtime to be paid. So if you are aware that employees are going to be well above 40 hours per week, you could have a salary that you could have an hourly rate that includes their overtime hours in a way, so that they end up making about the same. But you would have to lower their rate from it currently is right now. But when you include overtime at the end of each week, they would be essentially paid the same as they were getting paid prior to the new rules being effective. A last option is for nonprofits only. And if you are nonprofit, you could potentially consider the use of volunteers. But that only applies to certain nonprofits, such as religious, public service, or humanitarian nonprofits. And then, of course, the last option is to just give up and retire and stop dealing with this, of course.
But nobody should tell any of their employers that was part of our recommended possible options, because that's not going to go over well. So with that, we want to talk a little bit about the actual action steps that you should work through in deciding which of these options are best suited for your organization, given the particular concerns within your employee population. And the first really is, you've got to sit down and look at this and make a plan. December 1 isn't that far away, even though it feels like it right now when we're in the midst of the summer months. It'll come up fast, and you should really be looking to start making your plan now and know by the end of June how it is that you're going to tackle these changes, who's going to be working on it, and what kind of time frame are you going to be looking at. That might involve needing some kind of an HR consultant to help you with those kinds of changes or with that planning. Maybe you need to have an attorney involved in order to make a review of your positions that might be affected, not just potentially because of the salary, but maybe you also want to look at whether or not your positions are in fact meeting those duties tests, so it's not just a salary issue. Or maybe you just need to look at those potentially affected positions yourself. But that's something that you ought to be starting to do now, because really, quick fixes with these kinds of changes are rare. You've got to set aside the time to work through the problem and figure out what the best solution is.
Another option to consider after making a plan is to communicate with your employees about the changes that are going to be occurring. Because if you communicate now, you can address the headaches that result from these changes early on and manage those issues well before the changes are actually implemented. And one of the things that Carmen mentioned is that when employees do get switched from salary to hourly, there is going to be some heartache for the employees oftentimes, because they may lose some morale. So it would be good to inform employees of these changes well in advance and let them know that it has nothing to do with them or their abilities in any way. It's just simply the fact that the law has changed. the Department of Labor has changed these laws and that the employer needs to comply, and it has nothing to do with their performance in any way.
So then, what you need to do after getting your plan together, talking to people about, the fact that there might be some changes, you've got to dig into that self-diagnosis. You need to start looking at, what your existing salaries are and how your positions are classified. And, it may be, for some organizations, this may be a fairly quick process because maybe everybody's above the salary threshold and there are no changes to be made, or maybe there aren't that many changes to be made. But think about it, as sort of bucketing your salaried positions into three different tiers. One, you look at it and you say, no way, they're so far away from the salaried threshold. We're never going to bump them up to that salary. So those are the folks right away that you're talking about having to convert to non-exempt. And quite frankly, by doing so, you're also eliminating any risk that you might have about having them misclassified based upon their duties, because they're going to non-exempt anyway, and you're going to start paying them overtime. Then you've got the bucket of folks where, they're close, or you definitely, need them to stay exempt positions. So you say, look, we got to do it. We got to bump them up. We need these positions to stay exempt. And with those, you're going to increase the salary, but you also got to make sure that you do that double check that they satisfy the various duties tests for whatever exemption you're using for that position, whether it's the executive exemption or it's the learned professional exemption, or it's an administrative exemption. You've got to make sure that they meet both that salary and those duties. And then finally, you've got kind of that bucket of positions where, you're just not really sure. You've got to kind of do some analysis, take a look at what the effect of bumping them up would be. Are they questionable when it comes to duties? In order to kind of determine which way you're going to go. Are you going to bump them up and keep them exempt, or are you going to reclassify them and make them non-exempt? Really, once you start doing that, two of these three buckets of people become relatively straightforward, at least in terms of the decision-making process, and allow you to focus in on the decisions for that sort of questionable third bucket category.
So following up on Carmen's bucket options, in going through to determine how to comply with the new law, you would need to do an audit of how much employees actually work. So if usually with salaried employees, employers don't track their hours, so they don't know how much they're actually working. You may have an employee that is actually working a lot more overtime, and you may not be aware of it because you were never tracking their hours. So during the time between now and December 1st, you would need to go through and audit each of these positions and speak to your employees to actually determine how many hours they actually work. And if they're well above 40 hours, you should be aware that if you reclassify them, you're going to be hit with a lot of overtime. So in that case, you may need to add more employees, or you may need to figure out a way to classify them as exempt if that's even possible based on their duty. Another option is that if they're below 40 hours, then you should be okay, and you may not need to change their salary because their pay won't change in light of the new rule. So auditing the positions in detail is really important to do to determine how much you will be affected by the new rule.
And going along with sort of the how much work question is, can you sort of remodel the makeup your workforce, and do you want to? If you've got a situation where, you've got the work of one worker that now you've got to split up, into work that's being done by two folks or more than two folks, what are some of the consequences that you're going to have to work through and deal with? Are you creating, new benefit or leave or other kinds of employment issues by doing that? will it cause your employees to start, looking somewhere else because they don't like the fact that their hours have been reduced, potentially to 40 or below? Or maybe is there a positive impact? Can you grow your organization by bringing more people in and getting them involved in your work? One of the potential positive effects of having more workers is sometimes that means that folks who are managing your overall workforce now more clearly can fit within that executive classification, because maybe before you had people who were supervising one or no full-time employees, but now you've got some folks who are in fact supervising two or more full-time equivalents. Again, by adding up all of the various part-timers. So maybe you get some folks who are more easily classified as exempt by virtue of that. But you've got to look at all of these issues and how they're ultimately going to impact the workforce, and whether or not that's going to mean modifying, remodeling your work setup.
Another issue to consider is to think long-term regarding these changes. As Carmen mentioned, the salary requirement is going to be increasing again in 3 years. And so you would need to budget accordingly for future increases in these salary requirements, and make sure that the changes you're making now, you're going to be okay making in the future again. And then in addition to that, you should be aware that the reclassified employees will likely need training on how their new role would be treated. Going from exempt to non-exempt would require employees to clock in and clock out every day, and you would need to create a system for doing that. In addition to that, some states, including California and Wisconsin, have meal break requirements. So you would need to train employees on how to take a meal break and how to clock in and clock out for those meal breaks. In addition to that, once an employee becomes non-exempt, if they work remotely or from home, they need to be paid for that time. So the employer needs to be aware of a process to track those hours if they are working from home, or in some way limit those hours, because you may not be able to track how much somebody is working from home or via email if they have access to that when they leave the office.
And so really at the end of the day, the bottom line is, don't be shy about asking questions. Really dig in there. Talk to somebody about what might work best for your organization. These are changes that are going to be affecting nearly every employer and all across all kinds of industries. And so there's no stupid questions here. Everybody's still working through these same issues. And you can use your counsel, you can use information provided by the Department of Labor, of which there actually is quite a bit. You can use resources like SHRM and other HR organizations. If you've got questions or if you've got doubts about, what you're doing or whether there's a better way to do it, get some help. Certainly employees and, employee counsel, we'll be waiting and watching to see what happens come December 1st. So trying to figure it out and doing it right on the front end is certainly worth it, as opposed to having to deal with it when the first employee complains about what has happened, or their lawyer reaches out about some kind of a classification or reclassification issue.
And as we close out our presentation, we wanted you to be aware that there are many additional resources. Some of them are listed here in this slide, which you can get these slides online after the presentation, and you can click on any of these links to get more information, or you can email us with questions, and we're going to try to address some of them now in the next 10 minutes if possible. So I guess I can start by hitting on a few of these. We talked about, there's a lot of questions on the duties test. Employees must meet both the duties test as well as the salary to be exempt. Carmen, do you have one that you can touch upon really quick?
Yeah, I'm sorry. I sort of had one teed up. Sorry, it is not really on the duties, but it does relate to the salary issue, and it's the idea that you may have some employees in a particular classification or a particular job. I've got actually a few different questions with different jobs referenced here, and the question really is, what if I've got several employees in the same job, but I've got some of the employees who are paid over the new salary level, $47,476, and some that are paid, less than that salary level. Do I have to change that entire job classification over to non-exempt if I've got some people that are less than that $47,476 salary? Or, can I just change the people that are below that? And as far as the DOL is concerned, and as far as the legal requirements are concerned, these exemptions are looked at on an employee-by-employee basis, not necessarily a particular job or a particular classification. So for each employee, you're looking at, do they meet the duties of whatever exemption you're trying to apply? I mean, are they meeting the managerial duties? Are they meeting the administrative duties? Are they meeting the qualifications for the learned professional exemption? Are they meeting those duties, and are they above that minimum salary threshold, $47,476 at the least? If they are, those individual employees can be classified and stay classified as exempt, even if folks in that same job ultimately have to be converted to non-exempt. Now, the one qualifier as an attorney that I will add to that is having sort of some people be classified non-exempt and having some people be classified exempt in the same job does really raise a question as to what the appropriate classification is for that job, and it sort of puts more scrutiny on the exemption for those who are exempt. And so you really, really would have to make very sure that they fall squarely within those duties tests. There's no question that they meet the duties test, because if you've got some folks in the same job that are being deemed exempt and some that are being non-exempt, you're just asking for somebody to come in and challenge that exempt classification for the position. By the same token, you do have to think about the things that go along with those employee morale issues. If you've got somebody in the exact same job who doesn't have to track their time, who doesn't have to get approval to work overtime or more than 40 hours in a week, and some that do. So you have to think about those additional issues. But as far as the law is concerned, you look at that exemption on an employee-by-employee basis, and if it applies to a particular employee, that's all that's required.
Touching upon one other question that is pretty important, is what is the definition of work? The question arises regarding if an employee goes home and reads an email or responds to an email, is that considered work? Yes, that is work. If an employee is not exempt from the FLSA and they work from home, that time is work time. If they respond to an email, that is considered work time, and they need to be compensated for that time working from home. The only exception to that is if the employee is clearly exempt. Then you can avoid paying them for that time because it's already included within their salary. But if it's an hourly employee that's not exempt, any work from home, no matter what, is going to be work time that should be compensated. And if they go over 40 hours a week, they would get overtime for that work. So it's very important to limit working from home, if possible, for employees that are not exempt, because you have no way to track what they're doing from home, and you could get potentially hit with a lawsuit from an employee that claims he or she worked several hours from home that you were not aware of, and you would have to pay the employee after the fact for those hours worked from home. And if you don't have record to show how many hours they worked from home, it would basically be the employee's word against the company's, and the company would not have any records to show to dispute those hours.
We have another question here about asking, why we've omitted really any discussion about the sales and they say in marketing exemptions. As far as sales goes, sales is an interesting one because the titling of this final rule actually references outside sales being covered by this final rule. But the interesting thing is that the outside sales exemption currently does not have to satisfy the $455 per week salary requirement. It just has to satisfy essentially what are the duties test. They don't have that additional salary component. And so therefore, the changes to that minimum salary component don't really affect outside sales. Likewise, if you're talking about inside sales folks, that particular exemption is a separate exemption that isn't actually even covered by the final rule. And so you still go off of the current requirements for inside sales folks when you are looking at whether or not they're exempt. So it's a little bit of an oddity. The outside sales folks are referenced in the titling of the rule, but ultimately the sales or the salary changes don't actually affect those outside sales folks. And for inside sales, they're not actually even covered by this final rule. So that's why we have not really talked at length about either of those exemptions.
We have time to hit on one last question. The question is, if you reclassify someone to non-exempt, can they come back and ask for overtime after the fact? So this all depends on whether the employee meets those actual duties of being not exempt from the overtime. Sorry, if the employee is not exempt from the FLSA, the employee would be entitled to overtime. So if you reclassify somebody to non-exempt, they can come back and say they should be entitled to overtime, potentially, because then you have an issue where it all depends on if the duties that the employee was working prior to the reclassification were the same as they are after you reclassified. So there is a potential that if it was an employee that was exempt before and then you reclassified them to non-exempt, there is that possibility that the employee can come back and say, well, I was misclassified that entire time. So it does require consideration. I mean, you would need to reach out to counsel to figure out the best way to address that issue because there is that potential liability there.
I do actually have it. Oh, I'm sorry, Cam. I didn't know if you were finished.
No, go ahead.
Okay, I did have another question here, and it looks like we've still got some time. This one actually relates to the learned professional employees, and the question again here is, if the learned professional employee is making less than the new threshold, are they going to still be exempt from overtime regulations, or does this depend on what the majority of their time is spent on? So generally speaking, the learned professional employees are affected by these new salary requirements, and if they're making below that salary threshold, that new salary threshold of $47,476, they are no longer going to be exempt from overtime. You're going to have to reclassify them as non-exempt and pay them overtime for hours worked over 40. But there are, of course, a few exemptions even from that sort of overall general rule. And so there are a few classifications of professional employees that these new salary requirements still don't apply to because the old salary requirements didn't necessarily apply to them. And those are folks that are bona fide teachers. Their primary duty is teacher, and they are working in an educational institution. And also professionals who are licensed lawyers or doctors. The new salary requirements do not apply to those particular categories of professionals. So even if those folks are making less than the new threshold, they are still deemed exempt. But otherwise, other than those categories, if you're applying that learned professional exemption and you've got employees that are below that new threshold, they are not going to be exempt any longer come December 1. So I guess. Oh, I'm sorry. I was just going to say, I guess we've got a lot of questions coming in, and so I think what we're going to do is we'll try to follow up directly and address your questions after the webinar, because we do know this stuff is tricky and it's new, and so we will try to answer your questions after the webinar. So with that, I think we're all closed out, and we do thank you for your time. Certainly, again, we've got your questions from today and what we've received already through the webinar, but we've got our contact information up here, and if you've got particular questions or things that you're dying to have answered, feel free to reach out to either Cam or myself, and we will get back to you and try to help you answer those questions. So thanks very much, everyone.
Thank you.